Deputy Daly.
Thanks, Ceann Comhairle. Obviously, your amendments 4 and 10, Minister, are trying to roll back on the amendments that Deputy Wallace succeeded in getting past the committee. And our Amendment 5 here is really just a companion amendment to the ones that we did succeed in getting put through a committee, and is necessary if these two amendments remain in the bill, which I believe that they absolutely should be. I suppose the key points here for us, well, you know, the bill has undoubtedly improved a good bit from what it was originally, thanks in a large part to the work of Senator Alice Mary Higgins. But one of the biggest problems with it is these bits here, which is that it's fatally undermining the issue of voluntary consent, and is enshrining, if you like, coerced consent in a certain way, and that's why we will be sticking to our guns on these. I suppose there's a couple of things. I find it really unbelievable that we have to argue this point at all. To be honest, it's so really clearly wrong that the state would hold someone's social welfare payments hostage until the person surrenders and gives up the right to privacy, which is actually one of the fundamental rights under the ECHR. But that is how the PSC card has been used by the Department of Social Protection to date. What we're saying here is, if somebody wants to use the PSC to verify their identity, or if they want to give a body access to their public services identity, that's absolutely fine. We've no problem with that, and nothing that we're putting forward here impedes that. All we're saying is, if they don't want to do that, then they shouldn't have to do that. They should be able to produce, for example, a passport. When this issue has been raised before, and I don't know if the Minister has changed his tune on this and whether there's a difference now, because when it was raised previously, we've been told that there will be always alternative ways to verify your identity will be offered. You've said that previously. And if that was the case and you're still sticking to that, well then what's the harm in having our amendment in place? It's not going to undermine that at all. So I don't really sure where you're coming from in terms of that bit. And if it is, you know, if it isn't provided for an alternative mechanism, well, we think that it absolutely should be. We're not prescribing what the individual service provider should use. We actually don't care what they say the requirement should be, but we're just saying it can't be the only provision. And I think, leaving aside some of the amendments that were some of the discussions at committee, there is a serious point here. I mean, it's one thing to submit a photograph or a document with your address on it. It's quite another thing to be required to provide facial image biometric scan. And if we hear it again, I really hope you don't say it, that the PSC database doesn't store biometric database, we'll be, I don't know what, well, we're pretty sick listening to that, because the intrusiveness of the data requirements of the PSC means that the PSC is in breach of the requirement under EU and ECHR law that state interferences with privacy must be both necessary and proportionate. And the PSC is not necessary because alternative forms of identification, including passports, are available and were previously sufficient for the purposes of accessing public services. So the idea of systems breakdown going into overload applying here doesn't apply. Most people probably won't have a problem with offering the information, and that's fine. That's great if they do. It's for the people who don't want their data shared across a body of potentially 150 organisations and so on. And in that sense, the PSC is disproportionate because it requires people to link all of their personally identifiable information into one database shared by numerous agencies, and that interferes with privacy rights in a manner that far exceeds the stated goal of easy and convenient service access. So putting all this information, actually private information, even into a hackable database, to be honest with you, goes even further than that, and I actually frankly think it's absolute lunacy. And I think the key phrase really is state interference with privacy. Because you see, if the state asks somebody, you know, do you want to give us X, Y, Z parts of information about yourself, and in return we'll give you this handy little card now that you can use for all of your public service, a lot of people would say yes. And if the state asks, well then interference with privacy doesn't apply in that situation. When it becomes interference with privacy is when the state puts a gun to somebody's head and basically says, give me all your data or we're going to cut your services off. And I find it very difficult. I don't know why the government can't really get that point. And I think by interfering with privacy in a way that's neither necessary nor proportionate, I can guarantee you now, and I'm happy to put it on the record, the state is setting itself up for all sorts of problems, not just with the ECHR, but also with the GDPR, without question. Fines will be levied if the government succeeds in having our amendments removed. So I really hope they aren't, and that amendment number 5 is kept to go in tandem with it. Really, at the heart of these amendments is the idea of the once-only collection of data that the government is proposing, and it seems to be justified solely on the grounds of efficiency, so-called, although efficient for whom is not really clear. I suppose if you boil things down to basics, the bill has 2 main goals: to provide a legal basis for public bodies to share data between each other, the sharing bit as it were, and to set down safeguards for the individuals whose data is being shared, the governance in other words. And while the sharing bit is something that the government has clearly spent quite a lot of time thinking about, our key concern boils down to the fact that the governance aspect of it doesn't seem to be as well developed at all, and that is potentially a huge problem for the state in upcoming litigation in the years ahead. Now, one of the arguments for the sharing bit of this bill is that, well, it's an absolute pain if you have to give your to every public service body that you might have to interact with, if you have to give them your details every time you sign up. So it goes, the sharing is pitched as, well, this is just to make it super handy for everybody, that they have the information, so you don't need to bother about that. But not everybody will be of that view. If you like, if you take the example of Google, like Google is a really very handy search engine. Everybody would agree with that. But it also, what happens, it happens to do worrying and intrusive things with your data as well. Now, for a lot of people, they might say, well, that's fine. I'm happy with that trade-off. It doesn't really bother me all that much. And that's grand. Those people aren't affected by anything we're doing here. For most people, the trade-off is worth it. But not for everybody, and for some people it isn't. And I'd put it to you like, if the government was trying to implement a system where we all had to, by law, use Google and accept the privacy trade-off, that would be pretty extreme and outrageous, and there'd be a big outcry about that. But that's what the government is trying to do here in opposing our amendments. It's not really that different. What you're saying is, if you want to use public services, you must sacrifice control of your privacy data. A lot of people couldn't care less. That's a trade-off they'd be happy to make. But some people will care. And the law, and European law, is on their side. And we are setting ourselves up for a hiding to nothing if our amendments are not accepted here. We have heard the government say previously that the ability to opt out isn't necessary, because people have a right to having to object after their data has been shared. But that's a bit late after the damage is done. We don't think that that is sufficient. I think if we look at it, private data really is best understood as a form of private property, something that I thought Fine Gael deputies in particular would have been very fond of. And if we use that as a metaphor here, well, data then in that sense is really like your own private house. And what the single customer view does is give the keys of your house to hundreds of different people and tell them they can come in anytime they like without you asking them. And what our amendments are trying to do is say, OK, look, you individual person, you can have a copy of our keys. It's very nice of you to come in and feed the cats while I'm away, but I'd rather that you didn't share my keys with everybody else without asking me first from now on. That's not a huge ask. That's what's been done here. That's all we're looking for. It's eminently reasonable, to be honest. And now I know the government has said, oh, that might be a bit costly to implement that, but we're only talking about small numbers, because most people will accept the trade-off for the convenience. But as I say, not all. The numbers won't be big. But I have to again put on the record, and I'll use an example for it. It's extremely likely that the government will be forced down the line to give people an opt-out, whether by an individual case being taken to Europe or by the European Commission. And it's far better that we address this now, before more specified bodies come on board and rolling this back gets even more expensive. Because let's face it, that's what you're trying to do here. And we should say that we saw the other week the consequences of the government not listening when they were told that what they were doing wasn't legal and couldn't stand up. And we had the example of that in the Graham Dwyer case, who won his case with regard to the retention of mobile data. A former Chief Justice described the data retention and access system in Ireland as something that amounted to mass surveillance of the entire population and had told the government to fix it. The government ignored him. The Data Protection Commissioner, in her 2017 annual report, said that retaining the current regime of access to phone and internet records by state agencies is not an option. She said it's not an option. She was ignored too, and look where that mess got you. So really what we're saying here now, why don't we avoid setting ourselves up for another huge mess down the road, correct the problems that are there at the start by offering an opt-out for people who want one?
Amendments? Minister? Sorry, Deputy Eamon Ryan.